name is Gonzalo Funes, and I'm an attorney licensed here in the state of Florida. Today I want to talk to you about contract provisions, specifically attorney fee contract provisions. Now, mostly, and I'm sure all of you are aware, that we deal with contracts on an everyday basis. Some way we deal with contracts when we're trying to purchase or lease a certain parcel of land, or when we're trying to contract for services. And that's great. A lot of times, however, most of us don't read the fine print. Now that's up to an attorney to do. But in some of those contracts, there's a lot of standard provisions, what we in the industry call boilerplate provisions. And for the most part, those provisions are great. However, there are certain provisions that you would want to take a second look at or would want a professional to take a second look at. Specifically, what I'm talking about is the attorney fee provision in certain contracts. Now, this is a provision, and again, it's pretty standard across the board. Chances are, if you've had a contract before, there is a provision in there for attorney's fees. And what that provision basically says is, if there's any dispute arising out of the acts or services provided in that specific contract, that the quote-unquote prevailing party is allowed to receive their attorney's fees and costs. And that's a great clause to have in there because, again, if you have a dispute arising out of the contract, you want to be able to if you are the prevailing party, you want to be able to recoup your attorney's fees and costs because that comes out of your pocket. However, the challenge comes in understanding or really interpreting what a prevailing party is. Now, there's a plethora of case law out there that describes or tries to define what a prevailing party is for purposes of attorney's fees and costs. And the problem is that it really depends on the specific facts of each case and how that case gets finished in court. So, for instance, everyone's aware of a typical court case where you go to court, there's a jury trial, and if you get a judgment in your favor, that's a pretty easy circumstance where you can probably rest assured that you'd be considered the prevailing party. But consider this. What if you are the defendant in a case and you move to dismiss a complaint because there is some deficiency, and the court dismisses that complaint? Could you be considered a prevailing party in that particular instance? You are defending a case, but is it really a fact of where you prevailed on your claims as a defendant? That's a little bit of a sticky issue, and there's a lot of case law dealing with that. Now, a way to get around all this crazy legal jargon and really trying to define what a prevailing party is, what a prevailing party is not, is to have an attorney review your contracts and specifically delineate and change that attorney fee provision clause to allow you to define what exactly a prevailing party is. That way, you'd have no issues and the court would honor whatever that provision says within the contract to a reasonable degree. So that gives you the control and allows you to rest assured that you, as a party in a litigation, would be covered if in fact you are defending a case and it gets dismissed. That's just one of the very different clauses within a contract that can be amended to your benefit, along with everything else that a real estate or any professional can offer you. So my last parting words of advice is, before signing any contract that has to do with either obtaining services or either with a purchase or lease of land, I would recommend you have an attorney review that contract and potentially change some language around that will benefit you in the long run. Thank you.